Hello everyone, I'm Jed Rubenfeld and welcome back to Straight Down the Middle. Today I'm going to be talking about a very important recent Supreme Court case, the Rahimi case, the gun rights case. It's a fascinating case. It raises basic issues about the meaning of the Second Amendment, the nature of the right to own firearms, and even about the meaning of the Constitution itself. How do we interpret the Constitution? Well, I'm going to walk you through that. But listen, I got to tell you something in advance that we all know. Gun rights, Second Amendment, very divisive. One of the constitutional issues that's most divisive for people in this country. So to explain to you what's going on in Rahimi, I'm going to need to step back and try to explain to you what's going on with gun rights. What are the fundamental issues that underlie this whole debate about the Second Amendment? So I'll be doing that today. And here's one thing I can guarantee you. If you listen to this episode, you will understand the whole question about gun rights better than 99% of the people out there. You'll understand Rahimi better than 99% of the people out there, and maybe even better than some lawyers out there. And I can make one other promise to you. As I go through this tough issue of gun rights under the Constitution, my promise is I will walk you through it straight down the middle. Okay, so let's jump right in. The Rahimi case. There's this guy, Zaki Rahimi. He's not a nice guy. Case starts with the following facts. He assaults his girlfriend, physically assaults her. He grabs her by the wrist. He throws her into his car. They're having a fight, smashes her head. He's trying to drive off with her, but somebody sees what he's doing. There's a witness. So Rahimi, he goes to the underneath the passenger seat where he keeps a gun, and he brings the gun out. Well, while he's doing that, his girlfriend tries to run away. He comes out, he starts shooting. Now, we don't know, was he shooting at the girlfriend or the witness, but we know he was shooting. Then he calls her up and he says, "Don't report this to the police, because if you do, I'll kill you." Okay, so what happens next? The girlfriend, she's got guts. And she goes to the police despite his threat, and she says to them what happened. And she says she wants a restraining order. So they send her to a judge. She goes before the judge. She explains to the judge what happened. She says, "I don't feel safe. He's threatening to kill me, and I think he might be a danger to our kid too." She has a kid with Rahimi. And the judge, well, he gives Rahimi a chance to respond. Rahimi, it's a hearing. Rahimi can rebut these charges. He can deny them, but he does not deny them. And the judge says, "Okay, I'm entering that restraining order. And Rahimi, you are now prohibited for a period of time from contacting your girlfriend, from going anywhere near her house, going anywhere near the kid." So that's called a restraining order, and it's issued against Rahimi. Well, of course, he violates it. What does he do? He goes to her place one night, and he starts contacting her, but that's not all he's doing. This guy is involved in some 5 other gun-related incidents. For example, he threatens another woman with a gun. He gets arrested for that. He gets into a car accident. He comes out of his car, starts shooting into the other car. In another incident, he's shooting into somebody's house. So he's doing all this stuff, and the police are investigating him for these incidents. They get a warrant to search his house. They go into his house. What do they find? A gun, ammunition, and the restraining order. Because these police, there's different police departments. They didn't know about the restraining order. They see the restraining order, and they call the FBI. Why did they call the FBI? Because there's a federal statute that says if you're under a domestic violence restraining order where a judge has determined that you are a threat to the safety of your partner or a child, you cannot have a gun in your possession. That's a federal crime, and it's punishable by a serious term imprisonment. 10 years at the time this case arose, 15 years now. So the FBI and the federal government, they say, "We got this," and they prosecute him under this statute because it's open and shut. He's under the restraining order. He's got the gun. No problem. Open and shut case. He pleads guilty and then he appeals. Wait, Professor, you saying you can plead guilty and then appeal your conviction? Yes, that's right. You can preserve your right to appeal even though you pleaded guilty. Well, that's what his lawyers do. They then appeal the conviction. On what ground? They say that federal statute violates the Second Amendment. They say that under Supreme Court precedent, the Second Amendment means that every individual has a right to have a gun in his home for his own self-defense, and this statute violates the Second Amendment, and it's therefore unconstitutional. And guess what? The Fifth Circuit Court of Appeals, that's a federal appeals court, the Fifth Circuit says he's right. This statute's unconstitutional under the Second Amendment. Well, the government appeals that to the Supreme Court of the United States. And what does the Supreme Court say? They say, nope, that statute is constitutional. Fifth Circuit, you're reversed. And it's an 8-to-1 decision. That statute is constitutional under the Second Amendment. But there are a whole plethora of opinions issued by different justices in that case. And that's what people have been asking about. What's going on? How did the Fifth Circuit strike it down? And then how did the Supreme Court reverse it? What's going on with that? Well, to understand that, I got to take you through a little bit of the history of the Second Amendment. Now, many of you may think that the right to own a gun in your home for self-defense, that that is a constitutional right that's been enforced for centuries, that everybody knows that under the Second Amendment, everybody has a right to own a gun in their own home for self-defense. And if you think that, you'd be wrong. For 200 years, the Supreme Court took a completely different view of the Second Amendment and said, no. It doesn't guarantee an individual right to own a gun in your own home for self-defense. It's all about serving in the militia, the state militias. Well, I don't understand, Professor. The Second Amendment says the right of the people to keep and bear arms shall not be infringed. So how could the court not enforce that? Well, don't forget, there's a few other words before the words I just quoted from the Second Amendment. The Second Amendment reads in full, a well-regulated militia being necessary to the security of a free state, comma, the right of the people to keep and bear arms shall not be infringed. I'll repeat that. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Well, what does that mean? How do you interpret that? Well, for 200 years, the Supreme Court said, hey, because of that first clause, the Second Amendment is not about an individual right of gun ownership. It's about protecting state militias. And guess what? There was pretty good evidence of that from the 1780s that was what the Second Amendment was about. There's been a dispute about this for a long time. You can take one side or the other, but it wasn't crazy to think that the Second Amendment might be about militias, not an individual right to own guns. And that was the position taken by the Supreme Court right up until 2008. That's right, the Second Amendment has not protected an individual right to own guns for self-defense until 2008, just 16 years ago. Now, what happened in that case? This is the famous Heller case, written by Justice Scalia. And he says, he looks at the text and history, and he says, no, it's not about militias. We've been wrong for 2 centuries. And I'll tell you one basis for thinking we're wrong. I can show you all this evidence that shows from the 1860s, after the Civil War, when the country enacts the 14th Amendment, which secures for the first time the privileges and immunities of citizens. We've got all this evidence from the people who drafted and ratified the 14th Amendment that one of the fundamental rights of being a citizen of the United States, they said, was the right to own guns in your home for self-defense. And you know what? Scalia was right about that. You can find tons of evidence saying that's exactly what people thought when they were talking about the privileges and immunities, the basic fundamental rights of citizens in the 1860s and 70s. And what they were doing is, and this is explicit in the historical record, they're protecting African Americans, black people. Because black people in the South, the newly freed slaves, they were being terrorized by these folks who would ride up to their homes and burn their houses and threaten them. And you know the name of this group. It's called the Ku Klux Klan. And they were terrorizing the black people in their neighborhoods. And the folks who drafted and ratified the 14th Amendment, they said explicitly and frequently, one of the rights we want to protect is the right of every individual to bear arms and keep arms in their own home. And black people have that right just as much as white people. And in this country, everybody has a right to own a gun for self-defense. Scalia pointed at this evidence and said, see, that shows us that the right to bear arms and keep arms in this country is an individual right for self-defense. It's not just connected to the militia. But Scalia had a problem. Remember, Scalia is a famous originalist. What does that mean? It means that originalism is the view that the Constitution should be interpreted in accordance with the original understanding at the time of ratification. People say, well, what are you doing, Scalia? You're looking at evidence from the 1860s instead of the late 18th century when the Second Amendment was ratified. You can't do that. And he said, yes, I can, because we look at traditions, our country's traditions as well. Now, people were saying at the time, well, we don't understand. That's not originalist. That's something new. And a few years later, just a couple years ago, the Supreme Court picks up on that line from the Heller case and says, traditionalism, that's how you interpret the Second Amendment. Here's the test for deciding whether a gun law, a gun restriction law, is or isn't constitutional. This is what the court says in the later Bruin case. That's B-R-U-E-N. Just a couple of years ago, the Supreme Court says, if you can find a whole bunch of state laws or other laws restricting guns, if that's part of the tradition of this country, well, those laws are constitutional. If a bunch of states have laws that have been restricting gun rights in a certain way, and that was accepted, well, those are constitutional. And any new gun restricting law has got to be similar to those laws in order for it to be constitutional. That's what the court says in this Bruin case. Well, up comes the Rahimi case, and the Fifth Circuit says, we don't see any domestic violence disarmament laws in the historical record. we can't find any regulations that disarm people who are under a domestic violence restraining order. There's no exact parallel in the historical record. And under the Bruin case, we got to find an exact parallel, and we don't see that. Hence, the law, the federal statute, is unconstitutional. Well, the Supreme Court, in its Rahimi opinion, reversing the Fifth Circuit, said, no. You're interpreting our Bruin case too narrowly. You don't have to find an exact parallel. It just has to be analogous. And the Supreme Court then starts discussing these historical laws that it says, the majority opinion says, are analogous to these domestic abuse restraining order laws. And these historical laws are called surety laws and affray laws. We're digging through the historical archives, and I'm not going to go into them in detail here. But the Supreme Court is going through the historical record, doing this new traditionalism thing, and it says we find that this domestic violence disarmament law, the federal statute, is constitutional because we find in the older laws a principle that if a person has been adjudged to be a clear threat to the safety of another person, he can be disarmed. Well, the one dissenting justice, Justice Thomas, who wrote the Bruin opinion, he goes through the exact same historical record, the historical archives, and he says, he agrees with the Fifth Circuit. He says, no, these aren't close enough parallels, and he thinks you should strike down the whole statute and uphold the Fifth Circuit. So that's the difference between the 8 justices who agree and Justice Thomas who disagrees. But some of the justices in the 8, they are not so sure about this new methodology of traditionalism where you look at the historical record and laws from the late 18th century, the 19th century, and you ask whether they're analogous. So the 3 liberal justices, and I hate that term, but we're talking about Justices Kagan, Sotomayor, and Jackson, they file concurring opinions. They say, this is crazy. We shouldn't be looking at these ancient laws and trying to draw parallels. Look, here's how things should go. If the law serves very important state interests and it's narrowly drawn, we should uphold it. And we shouldn't be cramped and confined by the historical record of gun regulations back when guns weren't nearly as dangerous as they are now. So we should have a very different approach. Well, Justice Kavanaugh, he writes an opinion, a separate opinion for himself, and he says, no, don't go that route. If you start looking at the state interest that the law is trying to serve, and you balance that against the extent to which the law limits the liberties of individuals, you know what you're doing? You're doing a balancing test. And justices and judges should not be engaged in balancing tests, says Kavanaugh, when they're interpreting the Constitution. Instead, they should look at the original understanding, and Justice Scalia said in Heller, they should look at the traditions of this country. Okay, so that's the dispute between the various justices about how to read the Constitution. And let me tell you a little bit about what the issues are there. First of all, does Justice Kavanaugh have a point about what's wrong with balancing tests? I think he does. What is it that legislators are supposed to do when they pass a law? They're supposed to balance. At least this is what the argument would be. They're supposed to take the nation's interests into account, and if there are strong interests and there's not too much of an incursion on individual liberty, you balance that stuff, you decide what's best for the country, and you enact the law on the basis of that. Now, I'm not saying that's what legislators actually do, but that's what they're supposed to do. But you can make a pretty good argument that if that's what legislators are supposed to do, then judges should not be doing that. Because if judges are doing that, they're just acting like legislators. You got the justices of the Supreme Court who are acting like the super legislature, reviewing and deciding the law they're looking at was a good balance of interests, which is what the legislature is supposed to decide. So balancing tests have the justices kind of doing what legislators are supposed to do. And by the way, it's very difficult to objectively understand how a court's supposed to balance all these interests. We don't really have a way of measuring them objectively. And that's why, you let the legislatures do it, deciding what interests are most important. And you can really make an argument that justices and judges should not be doing balancing tests. But should they be doing traditionalism of the kind that Justice Kavanaugh supports and the Rahimi majority supports and Justice Scalia supported in the Heller case? Well, that's got some problems too. And let me be very clear what they are so you understand. Remember, the traditionalist view says, hey, if there's a law that's out there enacted after the Constitution was passed, these laws get passed by a bunch of states or the federal government, that makes it constitutional what they're doing. If laws got passed, they become part of the tradition. If they were accepted, well, then the court should not disturb those. Those, in fact, should tell us what the Constitution means. That's the traditionalist view as it's being applied in Heller and Bruin and Rahimi. Well, there's a problem with that. The problem is that it doesn't square too well with what the court has done in other constitutional areas. Let me explain. Think about racial segregation. For centuries in this country, the races were segregated. Even after the 14th Amendment was passed with the Great Equal Protection Clause, you had racial segregation of trains, of public schools, of water fountains, of swimming pools. You have a whole tradition of racial segregation. Well, there's a case that says all that's unconstitutional. Even though those laws were passed and they've been accepted for a long time, they're unconstitutional. They violate the real core meaning of the 14th Amendment. And I think you've heard of that Supreme Court case. That's Bruen versus Board of Education. And that's not the only case in which the Supreme Court does not follow this traditionalist methodology that you're seeing develop in the Second Amendment cases. I'll give you another example. Think about the First Amendment, the freedom of speech. At its core, paradigmatically, the freedom of speech means, today we understand it to mean, that everybody has a right to criticize the President of the United States or criticize a war that we get into. If the First Amendment means anything, it means that a person has the right to express that opinion, critical of the president, critical of a war that we get into. Well, guess what? There was a long tradition of throwing people in jail for such speech. That speech was called sedition. The United States has a long tradition of throwing people in jail for sedition. And I'm not talking about 200 years ago. Even in 1917, during the First World War, federal government passes a statute, a sedition law, throws people in jail who criticize the war, the First World War, throws people in jail for it. The statute is called the Sedition Act. Well, Justice Oliver Wendell Holmes, he says this is not constitutional. This violates the freedom of speech. In the United States, people have a right to express that opinion, but he's in dissent. The Supreme Court at that time upholds that statute. So we have a long tradition of throwing people in jail for sedition. But over the course of the 20th century, the Supreme Court would say, you know what? Justice Holmes was right. At its core, the First Amendment means, if it means anything, the right to express an opinion critical of the president, critical of a war. And that tradition of throwing people in jail for sedition, that was wrong. That was unconstitutional. So what I'm saying is that the traditionalist approach has problems too. If the balancing test has problems of having judges do what legislators are supposed to do, the traditionalist view, it's tough to square with some of the most important constitutional holdings and law that we have. Okay, so now I've taken you through some of the major issues about the Second Amendment itself and about how you interpret the Constitution. But let me step back and give you the bottom line here. What does the Rahimi case hold? It holds, as judges scour the historical record and look for analogs for modern gun regulations, they do not have to find an exact historical twin. They can find just something that's analogous, and they can extract a principle from those historical analogs. And we have the first principle now being announced by the Supreme Court. If a person has been adjudged to be a clear threat to the safety of another person, he can be disarmed. And this case is going to have big implications for cases down the road, like laws that say that felons can't own guns, and the new red flag laws that are being enacted. And maybe in another episode, I can tell you about how those implications might work. But for now, I hope that you understand the Rahimi case better, and thank you for listening.